Hi folks, Mark Merrill with Firm. Both sides now? Yep, on LD-2150. Like we haven't heard enough, right? Well, the recent public hearing on the latest curse that Governor Janet Mills is trying to enforce on Maine citizens, alias that bill, LD-2150, is far from becoming a law because of pushback from many citizens on both sides of the political spectrum here, and the Maine Department of Public Safety, which oversees the Maine State Police, which you're about to hear some testimony from one of their representatives. Now, just a quick review of this bill should make every resident in Maine shiver, like out in the cold, and every law-abiding American, not in hiding in sheep's clothing, by the way, from coast to coast, including Alaska and Hawaii. Everybody got that okay? First, American citizens, here's the beginning, or the first part, of both sides of the LD-2150 testimony statements from an attorney. We'll put her picture up first. Who you see before you now, ladies and gentlemen, is Alysia Melnick of the law firm Bernstein Shore out of the Portland area. So you put the screen a little bit better for us there. But she's representing the Maine ACLU, American Civil Liberties Union, in support of LD-2150. Here's how part of her testimony went.
My name is Alysia Melnick. I'm an attorney at Bernstein Shore, but I am here today pinch hitting for the ACLU of Maine and Michael Cavetta. I believe he submitted his testimony online, but if you have not received it, I'll make sure that it gets submitted right after I testify this morning. I am here today in support of LD-2150, an act to establish procedures for restricting access to state property, access to state services, and communication with or through state entities. And really appreciate Senator Grahowski going before me and really digging very deeply into a lot of the issues and questions that are covered by this bill. As I said, I'm here today on behalf of the American Civil Liberties Union of Maine, a statewide organization committed to advancing and preserving civil liberties guaranteed by our Maine and U.S. constitutions, and urge you to support LD-2150. As you've heard, this would establish a formal process by which the state and its agencies may restrict a person's access to state property, state services, or communication with or through a state entity. This process replaces an informal and inconsistent current process with a clear, understandable framework. LD-2150 requires that any restriction in accessing state services, property, or communicating with the state must be based on a documented, factual justification, communicated in writing to the restricted individual, and limited to 90 days unless subsequent action is taken to extend or renew the restriction.
Everybody got that already? Are you confused enough, folks? You know what it's a violation of? It's a violation of this right here. Your First Amendment rights. Not to mention law enforcement having their hands tied. We'll let her continue. But it's wrong. Firm speaks out. Because that's part of our job, is to inform you as to when your rights and freedoms are being completely violated by a political gang of thieves, treasonous and corruption, including the ACLU. Grant. Ms. Melnick represents her own law firm, but representing the ACLU doesn't exactly put another feather in her cap.
After After 90 days of restriction, the state must seek to extend or renew the restriction through an already existing judicial process, as you've heard, the protection from harassment process, which would ensure transparency and a neutral decision-making process. Prior to this legislation and under current law, there is no standard statutory framework for restricting an individual's access to the state or its agencies. Unwritten authority and informal practices are more dangerous than regulated ones because they are harder to monitor, more difficult to challenge, and applied unevenly. This legislation will enhance due process for individuals who are restricted from state services, state property, or communications, and we urge you to vote ought to pass. And I would also add that based on your all's discussions, I do think that there is the possibility that this could enhance the deterrence aspect of these orders, because if, as you said, if someone does not understand the reason for which they have this order or restriction, they are less likely to be able to avoid that behavior in the future. So I think that this is a good bill for all the reasons that you heard described by the sponsor, and I really appreciate your time. I'd be happy to try to answer questions or bring them back to the ACLU for the work session.
Heard enough, folks? Definitely not something that ought to pass. We'll give you details again, folks, so you can look up LD-2150 at your leisure. And download a copy of yours, and for family as well, and your files to keep handy, because we have an update as to where it stands in committee down at the State House in Augusta. Now, next up, folks, we have a gentleman here who is Tyler Stevenson, who's a major in the Maine State Police, who's going to testify in opposition to 2150. You'll find out why in just a couple of minutes here as we let things roll here a little bit further until his testimony comes up on our audio here in just a few moments. These sessions took place on the 29th of January, 2026, at a public hearing at the Joint Standing Committee of the Judiciary Committee of the Legislature.
Seeing none, thank you for your testimony, for presenting the ACLU.
The next gentleman, as we said here, folks, is right around the corner here. Be just one more moment here.
Thank you.
As again, we're talking about the introduction here of Tyler Stevenson, as you see, major from the Maine State Police, in opposition to this LD-2150, giving his statement. Giving some eye-opening revelation as to how this bill would affect rights and freedoms, not only of our state, folks, but the Constitution. Bill of Rights, Amendment 1 through 10, as it stands and has been for almost 250 years. But this nonsense from Janet Mills and her cronies has to stop. So here now, folks, is just a short 3.5-minute segment from testimony of Major Tyler Stevenson, the Maine State Police. in opposition to Bill LD-2150.
Good morning. Senator Carney, Representative Kuhn, and honorable members of the Committee on Judiciary. My name is Tyler Stevenson. I'm a major with the State Police, and I'm providing testimony on behalf of the State Police and the Maine Department of Public Safety in opposition to LD-2150 as written, an act to establish procedures for restricting access to state property, access to state services, and communication through state entities. This bill seeks to prohibit a state entity from issuing a no trespassing order that restricts a person's access to state property for more than 90 days and would require any 90-day trespass order to include a reason for the issuance. If it's determined that the restriction should extend beyond 90 days, the bill would require the state police to petition a district court for protection from harassment order to prevent the person from entering state property. In 2002, in State of Maine versus Mark Anthony, the Maine Supreme Court established that the lawfulness of a no trespassing order hinges on two factors: whether the premises are open to the public and whether the order was justified. Developed with this in mind, the current no trespassing procedure used by the Capitol Police is to investigate a complaint, determine whether an individual has a right to be on the property, and if so, whether their conduct justifies a no trespassing order. When an order is warranted, it is provided in writing, and the individual is given a phone number to contact if state services are needed. The order is in effect for 1 year, and if the individual believes the order is not warranted, they have the ability to file a complaint with Capitol Police leadership. This process is a common practice among law enforcement agencies throughout the state, and it is an effective means of stopping criminal behavior without resorting to criminal charges. We feel this approach appropriately balances the rights of the individuals to interact with the government and the rights of the public employees to feel safe while providing a public service. Over the past 5 years, the Capitol Police have issued 22 no trespassing orders for state facilities. None of these orders required an extension beyond a 1 year period. During the same time frame, Capitol Police records show that 5 arrests were made for trespassing after an order was violated, most occurring within a few days of the order being issued. The primary focus of our opposition to this bill is a requirement that we, the state police, seek protection from harassment order if it is deemed necessary to extend a no trespassing order beyond 90 days. The protection from harassment process has historically been initiated when an individual victim or business, not by the state of Maine. We foresee significant procedural concerns, including who would represent the state police in court, whether the state police would serve as a plaintiff on behalf of an individual who is being threatened or harassed, or whether the state police could act as a plaintiff on behalf of another agency requesting a no trespassing order. We also have concerns that the protection from harassment order is not applicable to all situations where a no trespassing order may be appropriate. Harassment is defined as 3 or more acts of intimidation, confrontation, physical force, or the threat of physical force directed against any person, family, or business made with the intention of causing fear, intimidation, or damage to personal property, and that do in fact cause fear, intimidation, or damage to personal property. There are numerous circumstances where trespassing notice may be justified but does not meet that definition.
Major, if you could wrap up in a sentence or two and then be available for questions.
Sure.
Interesting. Very interesting, Madam Chairwoman. Cut off right when he's making a lot of sense, folks. Mostly about your freedoms and your rights as citizens of this state, and hopefully the rest of the United States is listening. Minnesota, Massachusetts, New York, Michigan. You see where I'm coming from, folks? Blue states. Harassment. And we've got a couple more things coming down the pike, as we say up here in Maine. One more thing, folks. Actually, a couple of more things. We're going to look at some information from quorum.us on their site and the Maine Wire's website for more on how the First Amendment is being attacked by our state Democrats and yet another censorship action. Basically what it is, folks. It's exactly what it is. So, get even more bottom line, there it is. Plain old black and white. An act to establish procedures for restricting access to state property, access to state services, and communication with or through state entities. Huh? Yeah, it's bad enough, isn't it, folks? You have to wait in line at DHHS when you're having your case trying to be heard. Are you trying to get your driver's license renewed? Are you trying to go to any other state department, which is in reference to the entities, they call it? Any state office around the borders of this state, just to make sure that you're safe or you're not violating the parameters of this act. It's an act, all right. It's a dangerous one. So let's get to that information, folks, as far as the information we were talking about just now from Quorum and the Maine Wire. Find it quite interesting, I think. As for the Maine Wire, folks, the Democrat bill under the Maine Wire's website, which says mainewire.com/2026/01/LD-2150, the Democrat bill to allow the state to silence journalists. You can look that up and we'll post it on our comment section. The Democrat bill to allow the state to silence journalists they don't like. That bill was set for a public hearing back on the 30th of January. Would give government agencies the power to bar concerned citizens or even journalists from government property without due process and to prevent them from communicating with government officials. And it had a related story, folks. House Democrats attempting to ban Maine Wire reporter, a specific one, from House chambers. You can find that on Maine Wire TV. But going back to Senator Nicole Grohosky, who was on this initial page you saw when we started the program. There she is, folks. Ms. Grohosky. And the lady opposite her is Rachel Henderson, co-sponsors of this bill. But Senator Grohosky put forward initially LD-2150 with support from 7 Democrat co-sponsors. Liberal independent Senator Richard Bennett, yeah, right. He's about as independent as my armpit. And the Republican Rachel Henderson, who you just saw here. Now, the bill is drafted. It allows government agencies to restrict access to or communications with public officials and entities, state departments around every town, every city in this state, under Maine's harassment laws if they deem that a person has been too confrontational. Here's where it comes down to the bottom line from a Mr. Van Pate in his testimony against LD-2150. This gentleman is from the Maine Policy Institute. Quote, LD-2150 attempts to graft harassment law a doctrine designed to protect private individuals onto the government itself, but the state is not a private actor and it cannot claim to suffer fear or emotional distress in the same sense as a person can. While an individual attorney of the Attorney General's office could experience fear or harassment, that is not true for the office itself, which is a social construct. The bill allows an entity of the state to issue a communication restricting access for up to 90 days, where the 90 days came in there from the attorney there, of course, Ms. Melnick, up to 90 days before it is required to seek a formal complaint for protection against harassment. Where? Oh, from state government. Oh, who's going to enforce that? The state police? Don't think so. We just heard from a major in the Maine State Police Department saying he opposes it. If he's a major in the Maine State Police Department, which is a part of the Maine Public Safety Department, I don't think this is going anywhere. Do you, folks? We continue on the program here. Both sides now, when it comes to LD-2150. And we continue on, ladies and gentlemen, with a couple of more pieces of information here. Here's how it's promoted to you, the Maine people. A bill that establishes procedures for restricting access to state property. I may be repeating, folks, but we've got to think about our rights and our freedoms. Establish procedures for restricting access to state property and communication with state entities, and allows government agencies to bar individuals from government property without due process. That's a violation of your 4th and 5th Amendment, folks. If they, meaning the state, deem the individual as confrontational. It's been referred to committee on the judiciary and is currently under discussion regarding implications and potential amendments. Well, la-di-freaking-da. They know what they can do with it. And as we continue here, ladies and gentlemen, to wrap up this particular session of the program, Firm, with yours truly, Mark Merrill, going through both sides now. As it comes from not only the state police opposing, but our friends here at the Maine Wire, Steve Robinson, John Featherston, a gentleman you just heard from the Maine Policy Institute. The 132nd Legislature, second regular session, folks, back underway back at the beginning of January. You see, this bill, LD-2150, was just part of the agenda. Just to give a quick, brief, up-close notice of it. And the thing we need to have you look at closely here, folks, is the one right beside me here that says emergency. Oh, it's emergency legislation, is it? Right. To silence the people? Is that it? Well, right now, folks, this is the update we got recently before our podcast was recorded. LD-2150. Status is in committee. The latest committee action which was held on February 4th in work session, where it was held, has been tabled. That's right. We spoke and got an answer by email from the Legislative Council that monitors and prints out the sessions, the sessions of particular bills that are being held either in public hearing or work sessions. Tabled, but the latest committee report was not reported out. So we went and asked, folks. Hi again. We sent by email before this broadcast, folks. Since the Judiciary Committee had a work session on February 4th on LD-2150, it says on the legislature website status that it has been tabled and no committee reported out. Do you know what the next step is for this so-called emergency bill they, the lawmakers' sponsors, call it? So what happens when it's tabled? For how long? Thanks again as we look forward to your reply. Mark Merrill with Firm. A representative from the Legislative Council answered very quickly back. Quote, "We believe it will be rescheduled for a work session as early as next week," according to committee members. If you subscribe to the Judiciary Committee interested parties email list, you will receive notice of any new scheduled work session for the bill, and you can subscribe at this link. And we will supply that for you too, folks. You, as part of We the People, the state of Maine, who give a damn about law and order and freedoms and rights and the First Amendment and the Second Amendment and the Third, the Fourth, the Fifth, the Sixth, the 10th, and so on and so forth. You ask too many questions. We consider ourselves part of that right now, ladies and gentlemen. So that being said on this particular bill, folks, they went right ahead and have scheduled it for another session during the second week of February. Will most likely be rescheduled and reheard. In the meantime, folks, thank you for joining us. Mark Merrill here with Firm, Fairness in Reporting Media. Check out our podcasts all the time, right here at fairnessinreportingmedia@gmail.com, on YouTube, Twitter, and Substack. As always, everyone out there, stay safe, stay warm, and pray for our country. For the state of Maine, and for change in 2026 as well. Peace to all.